to get you through this training, I'm going to cover partway through manufacturer obligations, basically go through the basic components of the law and the background of the law. Cynthia will take you through the rest of the manufacturer obligations with a lot more details about reporting and that kind of thing. Then Jay's going to come up and he'll talk through the public education and outreach aspects of the program as well as enforcement issues. And then I'll take it back over and wrap you up with a look towards new regs, and then we'll hop in and talk to DEC as well. So we want this training to be very useful for all of the manufacturers, all of our participants. So please do hop in with a question. If you have it, those of you in the room, just push. Those on the web, you can use GoTo's question box to submit them through text. It's basically an instant messenger service on GoTo. You can use that, and we'll get your questions as soon as we can. So do send those along at any point. And with that overview, I'm going to dive right into any questions about the structure of today or what your materials are or anything like that. Great. All right, so we're going to start off with an overview of the law, and my favorite thing about this slide is the yellow jackets, which I guess people use in recycling and things. But basically, the whole structure of the law is set up to be a producer-responsible approach. So New York decided that it was going to be on the responsibility of the manufacturers to make sure that this law is implemented and to really achieve the goals of the law, which we'll get into in a moment. So manufacturers are responsible for the collection. There's a universal ban on disposal of electronic waste in New York through means that aren't covered by this statute. And any local or municipal laws were preempted when this law was enacted. So some cities across the country have been trending towards setting up different collection locations and putting obligations on manufacturers. This law in New York preempts all that, and this is the only law that you need to worry about in New York for New York-specific e-waste. The approach that New York took resembles that of a lot of other states that have undertaken e-waste laws. So today's session is going to be specifically about New York's law, similarly conceptually, but of course always know the laws of the jurisdiction that you're operating in. This presentation is not legal advice for you or your company, so know that you will need to work with your counsel if you have specific questions pertaining to your own obligations under this act. So again, similar to some other states, but we're covering New York in particular today, and don't worry, we won't dive into California's, which I'm told we would need at least a day on, so we'll spare you that. So whenever we talk about any statute, we want to know who's regulated under it. These are the regulated parties under the statute. It covers consumers, manufacturers and retailers, also solid and hazardous waste management facilities, manufacturers collectives, and the sites that actually do this collecting. For purposes of today's presentation, since you all are manufacturers, we're going to focus on the center two here, the manufacturers and the manufacturer collectives. But all of these parties are regulated under the law. So how do you know if you're a manufacturer? Hopefully those of you in the room are pretty confident that you are, but some might not know, or might work with other partners that might fall outside the bounds of this. But there is a specific definition of a manufacturer, and there's several factors that need to be considered. Your manufacturer, if you assemble covered electronic equipment, which we'll refer to as CEE throughout the rest of the presentation, for sale in New York. You manufacture CEE for sale in New York. You sell CEE in New York, so that covers some of the retailers, or you own a brand name licensed to another on CEE that's for sale in New York. If you import CEE to New York, or you manufacture under the same brand as another, you could have joint several liability for both companies to be responsible for handling the waste in those products. So you might think you know if you're a manufacturer or not, but don't worry, it's lined up here, and I'm really thankful that we have DEC on the line if anyone has specific questions about whether or not they're considered a manufacturer under the law. So there's like any good law, there's exceptions to every rule. So how are you not a manufacturer? Well, if you assemble fewer than 1,000 units of CE, so again, the covered electronic equipment in New York every year, or you primarily sell used electronics. So you can sell 999 products and not be covered under the law, but on the 1,000th, you're covered, you're a manufacturer, and you would have to comply with all the obligations that manufacturers have. So we're going to take a look at what the recycling goals are. As you'll learn, as we get into more of the implementation of the law, there's a statewide recycling goal set every year, and then each individual manufacturer's obligations can change underneath it. We'll get into a little bit more of a complicated for lawyers, but a formula later on that lets you know exactly what you're responsible for every year in recycling goals. So beginning in 2014, the formula is adjusted and it's based on averages over average weight. It's all weight based over the prior 3 years. So as you see in this chart, it can go up or down, but basically New York State is encouraging these goals overall statewide, and then they take these numbers and use it for the standards that manufacturers actually have to meet. But again, it can go up or down depending on the volume of sales happening in New York for the 3 prior years. So a little bit more on the scope of the law. We covered which entities are regulated, but the requirements apply to covered electronic equipment, as I mentioned. But let's get into a little bit more detail about what a CE is under this law. So what is covered? And you have a handout. I think it's labeled handout 1. Is that correct? Yes. Handout 1 is going to go into a lot more detail about what CE is in New York. But these are some of the general categories: computers, including tablets. And I'll probably use a tablet as my go-to example, one that I'm familiar with. And also computer peripherals, monitors, keyboards, scanners, printers, that type of thing. And all the tangles of cords that Colin here knows so well come along with all of this equipment. They're all covered. Also, other types of small electronics, video game consoles, video recorders, so I guess the old Walkman, walkie-talkies, or the things they record on from home alone. Cable boxes, satellite receivers, all these types of fun things are all covered under the Act. Small servers, so your modems, things like that. Televisions and cathode ray tubes. I had to look up what a cathode ray tube was. But again, like any good rule, there's going to be exceptions. So things that are not covered under this statute: GPS devices, radios, cameras, household appliances like the brave little toaster, LED picture frames, which I guess are a thing. Motor vehicle parts are not covered at all. Kind of interesting given the amount of high tech that goes into cars today, not covered under the law. Phones. A tablet's covered, but a phone's not. As the companies kind of merge the two, I'm curious. I have a question for DEC, how they kind of draw that line, but that's how it is in the statute. Phones are covered by a different law, the New York State Wireless Recycling Act. This went into effect in the beginning of 2007, and it basically requires all cell phone service providers to offer recycling and take-back programs. And the state also encourages consumers to donate their electronics to various organizations. So it's a similar law, but the cell phone providers are the ones responsible for the take-back programs. All right, any questions on whether you may or may not be a manufacturer, or if a product is or is not covered under the statute? Yeah.
What is the process for getting information on whether a product that may be in a gray area is covered?
So I'm going to go ahead and kick it over to Peter and Glenn on the phone if you have an answer to that question. It was how should manufacturers go about making determinations on products that may be in a gray area?
Yeah, if they have a question on whether a product is covered or not, they can just contact us here, send us an email or a phone call, and give us some details on the product, what it is, and we'll come back with a determination.
Great, thank you. Could you maybe speak a little bit about my cell phone tablet issue? Has that come up yet?
Oh, a tablet's considered a computer under New York state law. Cell phone is not. Cell phone's covered by the separate act.
So, and that, I mean, that's basically just whether or not it's used as a phone and has a cell provider is the only distinction between some of these products, correct?
Yeah, I mean, that's
Then you talk about tablets that has cell phone as well.
Sorry, if that was a response, we got kind of a muffled sound in the room. That's just the lawyer and me looking for the really tough hypothetical to sell to a law professor for their next round of finals.
When you ask that question, do you mean a tablet that has cell phone capabilities as well?
Yeah, so I mean, I just switched my cell phone, and my old product now no longer has cell service, but it can do all the things that a tablet can do.
Oh, no, if it was a cell phone and was designated as a cell phone, it's still a cell phone, so it would go under the Cell Phone Recycling Act.
Okay, great. Thank you very much. That was for my own curiosity, so thanks for indulging me there. All right, other questions? Great. So we're going to move on to some of the obligations that manufacturers have. There's 4 main obligations to register as a manufacturer in New York for the purposes of this act, to maintain a compliant U.S. acceptance program, and we'll get into the details of what those can look like in a moment. There are some public education aspects of the statute that we'll talk about, which Jay's going to cover, and an all-important annual report that, again, we'll go into detail on all this step by step. Even if you don't register as a manufacturer, all the other portions are under effect, so you can't hide behind, oh, I didn't know I was supposed to register, none of this can apply to me. No, registration is a requirement, but so are the other things, even if you fail to do that first part. There are penalties for each of these things, including failure to register, and we'll talk about the penalty provisions later on. So the first requirement is registration. That's what this guy's doing, apparently. Don't worry, it seems pretty simple. This guy looks a little bit more perplexed than he needs to be. There is online registration ability through DEC's website. There's a registration fee that you also submit. Manufacturers have a duty to update all of this, so if something changes on your end and you become a manufacturer, it's your job to update this. If you're changing the amount of product that you're selling, all of this needs to be updated, and it's on the manufacturer to keep this stuff up to date. We'll talk more about this specific website, but don't worry, it seems really straightforward, and I know DEC is available to provide all kinds of technical assistance for when you're trying to register to make sure that you're doing it absolutely right. You also have a duty to notify retailers of the take-back programs that you're using because they play an important role in partnering on this. So, new manufacturers have to register before selling in New York. Again, that's the 1,000 unit criteria. If you sell under that, you don't have to register, but at the sale of your 1,000th unit, you're then covered. You would need to have registered before you did that. There's the website that takes you to the registration page, which looks, oh no, it's not there, it's on mine, which looks like this. There's the registration page. Again, all of this is available in your materials. You can come back and get this information right off the slides later on. But basically, it's a 3-step instructions. You create an account, you complete your registration form, pay the applicable fee, and then it tells you how to do your annual reporting forms and your annual fees that go along with the reporting form. So you pay a fee to register, and then there's also a fee associated with your reporting form, which again, we'll get into all of this later on. But note that DEC has even given you a tutorial video. So you can watch this video right here. It's going to walk you through the entire process step by step. They've done a really nice job of providing a lot of material up front to show everyone how to do this. We're going to go into a little bit of detail here, so you can come back and see, okay, am I on the right page? Is this what it's supposed to look like? This is where you would create the account. Here would be where you access your registration form. The all-important fee information. There are a couple ways that you can go about collecting waste for recycling. You can do it as an individual. Individual manufacturers pay a $5,000 fee in the registration process. There's no registration fee for a collective. So your fee depends on whether or not you join a collective. If you're going it alone, it's $5,000. The collectives each pay $10,000. So again, once you're in a collective, they have their own rules about how that operates, how that works. But basically, it's a way to save some money by joining with other manufacturers and joining a cooperative to take care of this all for you. There are special cases where if you leave a collective and then you do an individual program, you're still on the hook for your $5,000. So if you become an individual if you do your own waste acceptance program, even if you were already under a cooperative, you're back in for the $5,000. Okay, so this is where you certify that you're a manufacturer. At this point, you print out the application from the website and you mail it in with the fee. So yes, you've submitted, but then you print it out and it actually goes in through the mail as well. And I wanted to check with DEC on the question of completing registration. I wasn't sure if registration is de facto at the point of submitting this stuff or if there's a response from DEC. Peter and Glenn, can you fill us in on that?
Once we receive the registration, we would look it over and assign the manufacturer a number, send it out in an email notification to them.
And when they receive the notification email, that's when they can consider themselves registered and complying with the registration requirement?
That's correct.
Great, thank you. Okay, so like I said, there's all kinds of technical support for all of this process. Here's phone numbers, step-by-step instructions are here, technical support phone number, and also an email address that you can reach out to them and get any other information you need. Questions on the registration process? Anything from the web? Don't forget, online participants, you can join us in the questions by submitting them through GoTo's question box, and we will get to them as soon as we can. So, like I said before, manufacturers have a duty to update. This is anytime that there's a material change in the information you submitted during the registration process, you have 30 days to take care of that. There's, of course, a definition of what a material change means. Your contact information, brand listing, the types of products that you're selling, details about your waste acceptance program, partner programs that you're joining with. All this is material. You can find more information about what all that means in your materials today. You may need to submit a revised registration form. You can always contact DEC to help you with that. They'll have to unlock your registration to go back in and change, is my understanding. So you're not able to just log on and redo it. You'll have to contact them. They'll unlock it. You'll be able to go back in and take care of it that way. But again, failure to update this stuff is a violation of the Act. So you always want to make sure that you're meeting that 30-day deadline. The other duty that manufacturers have is the duty to notify retailers. You have to notify your retail partners of registration in the program and inform the retailers who purchase CE how they can get involved in the recycling opportunity. So basically a way for them to let the customers know, because they have more interface generally than the manufacturers do, what the consumers can do with their waste when it's through its useful life. But we'll have more details on that in a moment. And I think that's where I stop and hand it over to Cynthia.
Good afternoon, everyone. We're going to go into the real substance of the program, which is your acceptance program. And we're going to be covering all of this. Again, this really gets into your duties to maintain a good electronic waste acceptance program that complies with the laws and also realizes the goal of this program is to keep this e-waste out of the municipal waste stream. So this is pretty important. We'll be going through all these in more detail. One thing I'll touch on now, which I will mention later, is it's important to accept the electronic waste continuously. So we're going to talk later what the manufacturer's acceptance standard is, what your goal is for each calendar year, but you still have to continue accepting it. Customer comes in with e-waste saying, no, we met our goals. You have to continue to accept it throughout the year. You can operate your program directly. You yourself can run this program, or you could work with an agent. There are other companies out there that do run these programs in partnership with you. And it has to be reasonably convenient. And we're going to go into the depth what exactly that means, because it's not necessarily as intuitive as you think. And at no cost to consumers. We'll go into what you need to do to educate the public and really explain how exactly this standard is calculated. And there's some assistance to that as well. So you have to always accept two types of e-waste. What you yourself have manufactured, a customer, you say you manufacture gizmos, you put out Gizmo 2.0, your customer wants that, so they bring back Gizmo 1.0, you have to accept that. Or they purchase several Gizmos 1.0, and you have to accept all of those. You also have to accept, I'm afraid to say, the e-waste from a competitor, but only on a one-for-one basis. So you make gizmos, your competitor makes gizmos, the customer buys one of your gizmos, you have to accept your competitors that your customer no longer wants. But only one. So someone brings in two pieces of your competitor's product or another manufacturer's product, you only have to accept one if the customer purchased one. So think of it as a one-for-one exchange. That's important to know. And Brett touched on this earlier. The program can either be an individual, one that you run yourself, or as part of a collective, subject to the same general requirement, but there's different registration obligations. Mostly what comes down is you will save quite a bit the more people participate in the collective. Reasonably convenient. So what exactly does that mean to be reasonably convenient? It's really all, I know, what we consider reasonably convenient to us, but it has to be from the perspective of the consumer to make it as easy as possible for consumers to turn in their e-waste so it does not end up in the dump, the landfill, or sitting in a drawer somewhere in the house that they have to figure out what to do with later. So you'll notice in one handout what we have is a list of the different counties and municipalities. So you have to have at least one method of collection per county and per municipality of this size. So you have to sort of figure this out geographically as well, but the handout should be some assistance. What exactly is a reasonably convenient method? As we say in the legal profession, depends. It really depends quite a bit on what you manufacture in some cases. It could be a community collection event. You've probably seen signs, e-waste pick up today or this Saturday at your community recreation center. It could be a fixed location site. And like the other example, a lot of retailers, you can work out an agreement, they will collect it for you. So a customer goes in to purchase a product, they can drop something off at the same time, and that makes it very easy. There to say the word again, convenient. That's what it all comes down to. A mail-back program, which we'll get into. A door-to-door pickup may be required. So if someone has a very large TV, the mail-back program is probably not going to work out too well for them. And the method has to be appropriate to the type of CE. So we're talking about the mail-back programs. If there's a very small device, that might be easier for your customer. It might be easier for you to manage that. But again, if you're selling larger types of equipment, that might not be the best way to do it. And you'll see this graph over here, which shows the results. You'll see that the mail-back program is a very small percentage. You can barely see it here. So permanent collection locations tend to work out best for the manufacturers and for the customers as well. So we have to thank DEC for doing crunching the numbers on this. Mailback program, some common issues. Again, it really comes down to making this as convenient as possible for your customers, but also prevent any back and forth or any consumer relations problems. You have to make certain that your website functions properly in terms of shipping labels. It has to be very clear on how to obtain the free, emphasis on free packaging. You have to be prompt in responding to email inquiries and accept all types of fees. So just think about your own personal customer relations issues from your perspective as a customer. When the website doesn't work very well, it can be very irritating. So I'm sure nobody here has an issue. You also have to pay for the packaging. You can't limit by weight or size unless there's an alternative method. So if you have a permanent collection site, you might think that taking televisions or large bulky equipment might not be so easy for you. So you can tell your customer, I'm afraid we can't take that by mail, but we have this other convenient option that you can take advantage of. And it's helpful to put all that on your website as well as sort of a one-stop shop for your customers to access. Any questions at this point on collection? Yes, sir.
Does the mailback have to be free besides the packaging and some of the other aspects of it?
I believe the entire has to be, all the costs can not be passed on to the customer. There are a couple of exceptions that we're going to go into a bit later. From DC, Peter, Glenn, do you have anything you want to add on that?
The answer to that question is yes. Everything has to be free. The consumer has to be given packaging if they need it. Shipping has to be paid for. So basically, yes, the entire program must be free to the consumer.
And that might be one reason why we see some of the other options are more popular, but it really depends what works best for your company in terms of cost and as far as accepting it. Data destruction, for a bit of good news. Oh, sorry, sir.
Can I ask you a quick question about the one-for-one?
Sure.
So does that mean, so you said you have to take, at least on a one-for-one basis, somebody else's product in addition to the one for, basically for everyone that you sell. So if you, say, sell 50,000 units into New York, that means you have to take up to 50,000 units of somebody else, is that right?
It's a one-for-one by a customer basis. So if a customer, it depends on what they buy from you. So if you sell them one item, use example of the gizmo, and they bring in one gizmo, you have to accept that. It's only one-for-one. So if they try to trick the system and bring in, all 10 of them, like we used to do with the printer cartridges going to Staples, we're talking about there, you only have to accept one. Of course, it's a good opportunity to convince them to purchase 9 more, but you only have to accept the same number that they purchase.
So how does this work for manufacturers when they sell in bulk to distributors?
Well, that's a good question. However, this is from the perspective of the end customer.
So the end customer. So if you're a manufacturer and your end customer is, say, Staples, then you mean it actually is the consumer that's the person. So this really only applies to retail sales?
Generally speaking, I don't know if DC wants to join in here on this, but we're thinking about the end user who's more of a typical consumer. So if you're talking about Staples who then turn around to sell to someone else, is that the situation you're thinking of?
Well, I'm trying to figure out who it applies to. Because I frankly have never understood the one-for-one. I think it's kind of stupid personally. But I didn't know if there was any interpretation. I wasn't familiar with that. Because I don't know how it applies other than the retailers.
Glenn or Peter, do you have anything to add? Or
Basically, it would be through your program partner, your recycler or your mailback program. If you're, you have a consumer who's purchased one of your products, a tablet, for instance, and they have an old, other brand tablet, and they want to send that into you through your mailback program, you would be obligated to accept that. Likewise, if you have a program, recycling program with a permanent collection site, you contract with them for weight, and they would accept your product. They would also be obligated to accept, other manufacturer's product with the purchase of your product at that recycling location.
And that one for
The collector has to collect the collector, not necessarily the...
I don't think anyone's ever tried to distinguish this. That's more or less it.
And there will be some opportunities as DEC works on regulations. This might help bring some clarification as well.
I think it's a problem. Thank you, Mark, for trying to explain.
Thank you. So we'll move on to data destruction. So the good news is there's no liability for manufacturers on any data a customer leaves. However, you do have to include information on how they can destroy the data before they turn it for recycling. So it's more of a due diligence issue. Cost. So that was a question earlier, was responsibility for cost. You cannot charge consumers. However, there are a couple of important exceptions. One is business consumers. So for profit, if your customers are a business, if they have more than 50, so 51 plus, and if it's a nonprofit with more than 75 employees, however, if it's a 501c3, that wouldn't apply. There's also premium services. Some of you offer some of these extra services where you're refurbishing, you're providing security, you're picking up obsolete equipment, and other services that DEC will be defining in its regulations. You would still be able to charge that. And you also have grandfathered in contracts existing like 6-7 years ago in 2011.
You go back.
Oh, certainly.
So what was the premium services refurbishment for reuse? I got hung up on that one because that's providing the value. Why would you be charging a consumer if we're taking it back in and reselling it? Or we can charge a consumer for recycling if we're taking it back in for refurbishment?
Well, I'll leave that part of that up to DEC, but that's additional service that you're providing, that you're picking it up, you're refurbishing it, and then if you're returning it back to them, or for another purpose.
So you could presumably charge a consumer for an item if you plan on reselling it for refurbishment for reuse. Am I missing something?
If DEC would like to chime in here, I want to make sure I get that correct.
Yeah, hey, if you accept back a product that needs to be refurbished, it can be refurbished and then resold, okay? Then you can charge for that product, but it's not the collection of the product, it's selling it again. You can charge for that used product by selling it.
You're selling it. It has nothing to do with
Yeah,
collection.
right. You're not charging the consumer who's bringing it to you. You're charging the person who's going to buy it from you for reuse.
Okay. But you can, so then moving up, you can charge a consumer, taking back a laptop today, I can't charge him for recycling, but I could charge him $20 for data destruction.
Yeah, if he, agrees to it, yeah.
Oh, yeah, fair enough. Okay.
No, I think these are some very good questions. So I want to make certain what your current arrangements are.
Actually, let me ask another question. So what if it's refurbished and then donated? That's allowed?
I'm going to go back to our experts here.
Sorry, I missed it.
So it can still be donated. You can refurbish it and donate it.
No, it's a good question as well. All right, recyclers. So,
Can you?
any recyclers you work with? Oh, do we have a question, comment here?
No, I'm sorry. Was there another question there about donation?
Yes, that's allowed, right? So you can refurbish and then donate it, right? And it still counts.
Sure. Yeah.
So once you have established a program, then you would be working with recyclers. So make certain that any of the sites, the consolidators or recyclers you work with are registered and they meet state requirements. Currently, the state does not require third-party certification. There's some organizations out there that do certify recyclers if they meet their standards criteria, but currently that's not required. However, it is a best practice. There are some places you can go for selection tips, so you can still check if they do have third-party certification. The two most familiar ones are R2 and eStewards. We're going to give you some tips on exercising due diligence, and if possible, we do recommend you visit the site to get a better idea of who you're working with. So here's some general questions to ask. I'll just touch on a few of them. Of course, many of you already do perform this type of due diligence. You want to know a bit about the history, especially the laws that they're working with, whether they comply, what their systems are for health, safety, what their process is, questions about how they export is important, how they ultimately dispose of this, actually recycle it. Of course, you want to make certain that they have all the appropriate insurance. And there's much more information over here on this website at the EPA that gives a lot more tips on things that you want to look for as you determine who you want to partner with. All right, the manufacturer acceptance standard, we mentioned that earlier, and this is essentially what your goal is individually as a manufacturer to collect every calendar year. And it's based on weight, which is kind of interesting if you sell very lightweight products, so they're a bit easier. And it's based on your market share after the statewide recycling goal, which we talked about at the beginning, is established. And it adjusts annually, but averages the 3 preceding years, so it can go up and down. And again, we talked about has to be continuous. And DC can talk a little bit more about not buying weight, which is essentially purchasing pounds. Would Glenn, Peter, and Mark like to explain a little bit more what purchasing pounds involves?
Basically, a manufacturer who really has no program in place and just goes out to a recycler towards the end of their program year and says, hey, I need, X amount of pounds. That's not a program. That doesn't help the consumer at all.
That's an important point we want to make. So sort of going back to the spirit of the law to keep this waste out of the waste stream. Okay, so there's the math portion of the program, so bear with us here. So the acceptance standard is you multiply the statewide recycling goal by your market share. What's your market share? You have your sales, your 3-year average of your sales, and you divide it by the total number of sales of covered equipment in the state, and that determines your market share. So we have an example where you have the recycling goal, your sales, all New York sales, you figure out your market share, and you multiply that to get your acceptance standard, which is your goal for that calendar year. And we have several examples. I won't painfully go through each one, but we have those on the PowerPoint you'll be able to access. And one reason is because it's already available online for you. So that's where a lot of this information is. So when you log back into your account, you can look under your reports and you could find the market share and acceptance standards. Now, part of this is based on information you'll be reporting, but it helps you calculate what you need to aim for that year.
Quick question on,
Yes, sir.
on that. What's the timing of the point at which we're the manufacturer reporting, and then when you get your acceptance standard? What's the time frame between that?
Well, the collection is for the calendar year, and I believe you get it at a certain point. I'm actually going to ask Mark, Glenn, and Peter when exactly they should expect that information to be made available.
Hi, this is Glenn. Annual reports are due March 1st, and we strive to get acceptance standards out in early June. We could get them out much sooner, assuming all manufacturers would get their annual reports on time, but every year we have a number of manufacturers who are late. This year we got them out on June 8th, and we did last year as well. Our goal is to get them out as early as May, but again, it depends on the manufacturers reporting timely and accurately for us to be able to do so.
So it works that well, so it's a good reason to provide your reports as soon as possible. You can get that information shortly, and they can calculate that goal.
Tell your friend.
Yes.
Tell your competitor. It's a new definition of friend.
No, I think that's a very good point to make as you time this out through the year. Surcharges. This is not going to apply to anyone here, correct? Because you're all going to have outstanding programs after learning about this. But this is what happens if you do not, or your competitor, will use your competitor's example, does not meet the acceptance standard. So essentially, it's an additional amount that you are surcharged based on what the shortfall is. The most important point to make is that the greater the shortfall amount, the higher the rate for calculating what the surcharge is, which you can see here. DC can waive, and we'll go into that. So here are a couple of examples. Again, I won't read it off, but you'll see here that if you, depending on how great the shortfall is, that really is going to make a difference in what your surcharge will end up being. So the takeaway is to have a great collection program, and you won't have to worry about this. But if for some reason where you would qualify as a waiver, this is how it would be calculated. Any questions on this so far? Okay. Because everyone here is confident this will not apply to you. Okay. Waiver regulations. Again, if despite your best efforts, you do not need it, you can put in a waiver request. You sort of explain what your program is, why it is a good program, why you met all the requirements, all the actions you've been taking, any corrective steps you realize you need to make, and you can fill in the waiver. So the department you would contact DEC, and then they would provide that form to you. On the other hand, this is something everyone here certainly will be interested in, is credit. So you go above and beyond, and you receive credit for exceeding your acceptance standards. And these are pretty fungible. You can purchase them, sell them, trade them, or bank them, subject to some exceptions. You have to report all this in your annual report. So whatever was transacted, how much you retained, what you used to go toward your acceptance standard, and some more information on purchasing. There are some restrictions. The most important ones in food, you can't meet more than 25% of your goal for that year using credit. They do expire, so kind of use them or lose them, but you can sell them. So there are several options here. And there's a first in, first out order applying to any surcharges. So for example, you build up credits one year, but for some reason the next year you find yourself facing a surcharge, you can apply those credits to the program. Oh, yes, sir.
Can I go back and ask about the waiver?
Certainly.
The previous slide. So is there, actually one more.
Yes, thank you.
The waiver regulation, is there any guidance on when this will apply? I see the request, but it has to include. And the reason I ask is because the law is set up based on the target is 3 years average, previous 3 years returns. And as we are going into a declining weight environment on returns, because those CRTs are no longer going to be there, we're going to be seeing a lot of these over the next few years. So is that something that's, is there any guidance on when this might apply? Because there's no way, I mean, it's basically the system's set up to fail over the next 10 years in terms of hitting the target.
That's a good point. I'm going to ask her from DC because that is a very good point. Though it averages out, so it might self-correct at a certain point.
It averages out, but not while there's a decline.
Oh no, I mean yeah, that's looking into it. Peter, Glenn, do you have any comments to make on that?
The waiver process is something that we are, going to be doing. It's going to be new to us as it begins to happen. We're not too concerned that the drop-off is going to be too immediate. There is the 3-year average, and we believe that while, amounts out there will decrease some from all information we receive from recyclers, they are well over collecting at this point already, significantly. So it will just begin to eat into some of that over collection that recyclers are seeing at this time. So for the waivers, what's going to happen is it's going to be a high hurdle for manufacturers, but if a manufacturer can show to us that despite their best efforts, they had a significantly strong program, they had collection events, they had collection sites, their mailback program was working, and they still did not make their acceptance standard, then the department would seriously consider a waiver for their surcharge. But again, it's going to be a high hurdle for you guys to get over showing us. So the best thing to do is you're going to have good relationships with your recyclers and your collection sites and all the people in your network. Keep good records and then be able to demonstrate those records to us showing your best effort.
Thank you. And this again makes a good point why it's important to really pay attention to the requirements of the program, making certain that your program meets the standards. So again, if you can show these things, that's quite important. I think that's a good question to ask for a number of manufacturers here. So we'll go back to credits. So we covered this. And again, the credits, if you purchase the credits from another manufacturer or collective, you have to apply to that year's first. So it's kind of like the first in terms of the order. So you would apply it to the current year's acceptance standard before you can't use it to meet subsequent years only. And a few more restrictions as well. You can't sell purchase credits. You can sell your own credits, but not those you purchased elsewhere. And if you anticipate surcharge, again, you need to use your available credits first to cover it. So just a lot of this has to do with the order that you use these. Any questions about the credits? And to know, DC is working on some regulations, drafting regulations currently, and we'll be discussing that a bit later. So that's a good opportunity to provide some feedback. And my pleasure to have Jay come up and talk about education.
Thank you, Cynthia. So I'm going to cover the public education program and also enforcement and implementation. Public education is a required part of the program. The basic requirements are to have a website, toll-free phone number, written information provided, a good idea to provide additional outreach, whether it's advertisements, promotion of the one-time events, press releases, etc. So we'll go into some of the things about public education. Probably you don't need this, but the standard is that your education effort has to be designed to inform consumers about how to access the recycling reuse options. Also important in your education program to be providing consumers information about data destruction. So the instructions on how consumers can destroy data are required. Remember, you do not have to, you're under no obligation to destroy their data for them unless you contract with them for that service. Your website has to have a listing of every location within New York State where they can return the covered electronic equipment. Things to make sure, ELI is a nonprofit, operates a website. We frequently have to go through and find the links and making sure our links work. Those kinds of things are kind of obvious, but you do have to police that, make sure that it works, make sure you have your data destruction instructions on your website. Explain about, so the question about what does one-for-one mean is an important piece of information, and you should try and explain that to consumers. Get the answers. We've got DEC on the line. We can figure out how that works. And make sure that, when you're providing a phone number that it works, that there's a way to get to the consumers. Consumers can get the information. That's the key to all of this. That the search functions work so that people can find it. That you're providing locations and dates, keep it up to date so that people can find out what's really going on. Manufacturers obviously are selling throughout the country. but you need to have New York State specific information available. And you know, if you are working with a collective, then the manufacturer should have links to the collective's information. Labeling, relatively simple requirement, visible permanent manufacturer label. I think everybody wants to do that anyway. But, so now we'll talk, well, if there's any questions about education programs. Talk about the reporting requirements. You've seen this before, the screenshot of the DEC reporting, or the site reporting form. You get on the site, and there is information DEC has provided on how to use the website. You do is the annual report, you log in, you'll get to your dashboard, and click go, and get started. I guess the key here is the plus icon, and then you can get to where you're either doing a report for a manufacturer or collective. There are different ways of doing it. In your annual report, there is a fair amount of information you have to provide. It's basically designed so that you can, so the DEC has the information so that you know, they're being able to come up with the acceptance standard and other things. So sales data, the weight of equipment that you've accepted, your status in terms of credits and surcharges, how you've collected covered electronic equipment, where it was collected, so listing of the facilities and sites, reporting on all your brands, so that DEC will know, and then an explanation of your program. So the sales data is important, obviously, for the determining what your acceptance standard is. So it's by weight, sold in the state in the calendar year, and also categorized by type. If you cannot provide all of that information, then you can do it by estimating, and then you do basically with your national sales data by weight, population, and then you know, to the proportion that would fit for New York's state population. And then you complete your acceptance results by the program partners. This is for manufacturers that are operating individual programs, reporting about your program partners. If you're working through a collective, then the collective will do a similar type of reporting. And then put in here for the program partner, you're going to have similar kinds of information in terms of source, the weight by type of covered equipment, and one of the things to keep track of is DEC has been modifying its website, so you know, keep watching for improvements in the website. It's something that's been ongoing. And then, as with the registration, when you finish with your report, you click the certification box, print, sign, and mail the certification form. Then click your submit to the program and submit your fee with the invoice. So the fees, basically you're waiting on the invoice. Goal is to receive the invoices in January. You can pay online for an additional fee or by check. And on the surcharge fees, the department will contact you and give you the payment date and issue an invoice for that. Record keeping requirements, you have to keep your records for 3 years and make them available for audit and inspection. Fairly typical requirements. So, enforcement, implementation.
To go back really quick, a question on the reporting. Is there any intention for DEC to have a more robust reporting system that allows each level to just report up one level? So I know one of the challenges for manufacturers is they have to report by every program partner and materials consolidated at consolidation facilities and then again consolidated at recycling facilities. So it becomes difficult to track one specific pound back to the original collection site where it was dropped off. Are there any thoughts and ways to improve that? Because it sounds like through some of this there might be some regulation development happening by DEC.
Peter and Glenn, do you have, were you able to hear that first, I guess?
Yeah, I think I heard it. Right now, the manufacturer, when they report, or the collector for that matter, they would report down to the collection site level. So they go through a recycler, and then they would report the weight where that recycler obtained from a collection site or a consolidation facility, and then down to a collection site.
Any plans for
Any plans to help streamline that process so that each tier is only reporting either up or down one level?
Really, there's not, because it's really the only way that if we are to run a full audit of a recycler and what they offer to a manufacturer to ensure that pounds aren't being double counted by the recycler or pounds weren't given to a manufacturer that were already given to somebody else. At this time, there's no plans to change that system. We have been working with our vendor to see if we can find a way to better do it in the system, but as of right now, that's not an option with our software vendor. So it is going to be the cumbersome process for the foreseeable future, but it really is necessary for us to be able to make sure that pounds that are being reported to us are actual pounds.
All right, thank you. All right, so enforcement and implementation. Penalties can be assessed by the DEC and by court. Can also issue orders, cease violation. You do have an opportunity for hearing. You receive an order or assessed penalty, and the penalties are deposited into the New York State Environmental Protection Fund. Penalties can be imposed for failure to submit your registration. I think Cynthia mentioned this earlier. All the obligations apply, but failure to submit registration or report or the fees or the surcharge. And those, the penalty is not to exceed $1,000 for each day not submitted. Violation of other provisions except for the not meeting the manufacturer's acceptance standard, which is addressed through surcharges. The other violations are $1,000 for the first violation and then escalating after that. So there have been has been enforcement under the statute. 19 manufacturers were cited for violations in 2014 and 2015 for non-reporting and incorrect information or program shortfalls. And here you have, the reported collection. So it has been successful in recycling. Had the discussion about whether it's going to fall off. The DEC folks are fairly confident that it's continuing. I guess there is a lot of built-up demand for recycling. Yes.
So I wanted to ask about that because earlier I thought that it was implied that there was a fairly significant over-collection. And if I'm reading this right, in 2015 we have manufacturer collection exceeding the goal and both the site facility collection by, it looks like, a substantial amount. So maybe DEC could explain that, or?
Can you guys explain?
Because it doesn't look like there's any significant over-collection on the part of the sites of the recyclers.
The site facility collection here represents sites, facilities registered in New York State. A lot of manufacturers obtain weight from out-of-state recyclers who've come into New York State and collected the weight here in collection events or pickups, business pickups, etc. And that weight does not get included on the collection side. We are trying to address that in the rulemaking to obtain, to capture that weight that's disappearing from the collection side of New York State.
And there is another reason for my statement earlier of a significant overcollection, and that is despite the fact that manufacturers are supposed to have continuous programs and collect all year, there are some manufacturers out there who will contract with a recycler for their acceptance standard or for just a few pounds over. And so a recycler may have contracts for 5 million pounds from their manufacturers, but they get 6.5 million pounds from consumers. So that was what I meant by significant overcollection in some cases. And we hear this from many of our recyclers in New York that this is the situation. So that explains it. It may not show there, but the pounds are out there. It's just some manufacturers do not have continuous programs all year.
All right. Thank you. Any other questions? Otherwise, I'll turn it over to Brett.
All right, another fun cover slide here for you. We're going to Mars, I guess. So in this final section, we're going to talk about some things that are happening with these regulations. I'm going to give DC a chance to talk as much as they want about that. So here's your notice, fellas. I'll be turning over to you soon and then open it up for questions to them. And then finally, we're going to talk just a little bit about large-scale kind of meta product stewardship and why this is important and kind of how organizations like ELI and some of the people in the environmental law and policy world are thinking about these issues overall. So CEC has new regulations being promulgated. These are, like any good regulations, provide clarity of the law, to strengthen the law, and to improve performance. It's about all you can ask for in a regulation. If they can achieve those, we're doing well. But specifically, the new e-waste rules are going to cover the things you see on the screen. Reuse standards, talk about credits and surcharges, state sales issues, some new definitions and revised definitions, more on the education and more on all of this. These new regulations are in the process. Like I said, there were preliminary workshops late last year. Final regulations are being drafted now, and they will be released for public comment. You can follow along with what's going on here on the website at the bottom of this page. But I wanted to ask Peter and Glenn if there was any word on the timeline or any other information that we can share with this group.
I mean, we were going to talk about that when we had our little spiel, but right now, I guess since you've asked, we are in the process of it. We are in the final stages of getting our draft up through legal and into the executive's hands, and we're hoping that you will have the regulations out for public comment later this fall or by the end of the year. And the optimistic hope is that the regulations will go into effect sometime in spring to summer of 2018.
I should have set that up better. It is time for your spiel now, so I meant to segue into that a little smoother. But you have the floor if you're prepared for that, and then I'm going to come back and finish up the product stewardship section. Does that work?
That works. 1 second.
All right. All right, so we just wanted to talk about the statewide goal for 2017 was released obviously back on June 8th. There was no hard copy sent out to manufacturers. That would be accessible online via the retrack system. For those who don't know, it was 99,702,748 is the goal for 2017. And it was also emailed to the primary contacts for the manufacturers. So you should all have that. Shouldn't be any issues. We have a governance report is up in executive right now. It contains information for the program for 2013, 2014, and 2015, and that should hopefully be available to the public shortly. We wanted to touch on some issues regarding compliance. Earlier in the program, in the early years when the act was first implemented, the department was more forgiving in issues of enforcement, but we have in the past couple of years or so stepped up on the issuance of notices of violation and orders on consent for the more grievous violations. This would be like misreporting of sales data over several years, not just the first occurrence, things like that. So we're trying to get the manufacturers to maintain compliant programs by keeping their contact information up to date so that they can receive notifications from the department and informing us of changes to their programs. And try to take a more hands-on approach with your program partners, your recyclers, those in the collectives, to maintain a close working relationship with the collective, and not let it go. And then, in some instances, this has happened where manufacturers have contacted who they thought they were in a collective, and turns out the collective did not collect for them for that year. So we've had issues like that. That's totally, it's really kind of silly for a manufacturer to just sit by and let the entire year go by and then realize that nothing was collected on their behalf. So we'd also like to have the manufacturers take more proactive steps in education and outreach to consumers to try to get the word out for their programs. Obviously, as through this presentation, it's shown that there's numerous requirements of our program, and it's going to take an effort on the manufacturer's part to maintain a compliant program.
My thunder kind of got taken here. I was going to talk a little bit about the rulemaking process, but you guys covered it pretty well. Just a couple things that I can say. we can't talk a whole lot about the rulemaking. We can't go very much into depth at it at this point. So you know, we may have to be a little vague on some things with you if you have questions. But other things that we are going to be addressing are methods of acceptance and what is an acceptable, effective, convenient program for you to offer consumers of the state. We are looking to plug the out-of-state data gap that Pete mentioned a little bit ago by having that weight reported to us as well, and that will help on that site facility side, which you correctly noted was lower than the manufacturer collection. And we're also going to take a close look at cost issues and manufacturer responsibilities regarding those cost issues and how those can be better, you know, taken care of, and the cost can be more on the towards the manufacturers rather than the consumer, which in some cases is what happens. And like I said, that you guys talked about the rest of my rulemaking stuff, so I guess it's open to questions now if you guys have any for us.
Thanks so much, everyone at DEC. I'd like to remind our webinar audience that you do have the opportunity to ask questions to the GoToWebinar question box. Like I said, the last section of the presentation is about product stewardship in general. So if there's questions about this statute that we've been talking about today, specifically for DEC, now is your chance to ask.
Actually, I have a question, and for DEC. So the statute, the law clearly allows for certain B2B, business-to-business generated electronics to count towards the acceptance standard. What role do those pounds play, or does picking electronics from, say, businesses, what role does that play in providing an overall program? Because I understand you want to make sure that there's a program, but is there any role in those collection activities, those types of collection activities, in fulfilling the program requirement?
Well, you certainly can, you know, offer, your recycler certainly can offer, and you can work with a recycler that does business-to-business pickup, and those pounds are eligible as long as it falls under the premium service definition. But that still does not negate your responsibility to have collection available to all consumers of the state. So you still need to provide, you know, Joe Smith an opportunity to recycle his TV or his computer, and that should be part of your continuous program.
Okay, thank you. That helps.
Other questions in the room? Anything on the web? All right, you still have a shot to get your questions in. I'm gonna go through this last section of the presentation, and then we can come back to them if we have them. DEC, is there anything else on your end that you want to convey at this point?
No, not right now.
All right, thanks a lot. It's a question about the slides. Cynthia, can you read it off that screen so I can follow along and answer this?
The slide that showed the totals, that one?
That question.
Certainly, the slide that showed the totals collected over the past several years showed for each year the statewide goal, the amount collected by manufacturers, and the amount collected by facilities. You add the second and third columns together to get the total amount collected. And then a comment that if you do that, seems to be the collection greatly exceed the statewide goal.
Right. That's what we've been talking about as we looked at this chart ourselves. but these are total pounds for both the manufacturing and site collection. So, yeah, those get added together for the overall.
Those are no way. There's no way.
That's not correct. No,
Correct me then.
the manufacturer collection would include weight that's collected by New York State registered facilities.
Right, okay.
The blue bar represents total pounds reported by those collection facilities as well. When you see that difference usually in between the manufacturer collection and, the manufacturers also obtaining weight from out-of-state recyclers who come into New York and pick up weight from collection events, et cetera, business, pickups. That material doesn't get counted by the collection side in New York State. So you can't add the second and third bar together. That would be double counting.
But doesn't DEC have that information on the manufacturer's annual report, what is reported from out-of-state entities? To be able to provide them the full picture to those of us, for example, having another bar then that really is the true amount collected, both from out-of-state entities and those required to report.
We do get that information from you guys when you report it on your manufacturer annual report, but we cannot include that in the site facility side because we do not get reports from those out-of-state facilities. So that is why the manufacturer side is higher. The manufacturers are reporting a lot of that weight that is being collected and brought outside the state and not being reported on the site facility side. Hopefully, as we talked about with rulemaking, the data gap, that problem will be alleviated, and I think you'll see that the site facility side will go up significantly because we do believe that even in addition to what you see with the manufacturers collecting, there's more weight going out of state than manufacturers are even claiming.
So when you say out-of-state weight, you're talking about out-of-state recyclers, or are you talking about?
Right. We're talking about a recycler from New Jersey coming into New York City and doing collection events or business-to-business pickup or anything like that and taking it right back out of state. It never lands anywhere in New York that has a registered facility. So when that happens, that weight leaves the state. We don't know about it unless a manufacturer reports it on their annual report or a collective.
So do you have any estimate of that differential?
I mean, I think you can see some of it there. We think it's significant. We really don't know for sure. But I mean, I think you can see in just the 2015 that there's a good number of millions of pounds there that the site facility side didn't report, but the manufacturer side did.
So I guess we can eyeball it by it's the difference between the second bar and the third bar. Is that right?
More than that.
At least, yeah, at least that.
Right.
And why would it be bigger than that?
Because a recycler may come into the state and do business-to-business pickups, cherry picking, very good equipment that it makes sense for them to pay a business to buy or whatever, and then take it out of state. Or it may be, even if they're not buying it, it may be worth them, spending the fuel to come over, get the stuff, and then they can go and, sell it themselves or break it down for the commodities, and they don't necessarily need a manufacturer to support that because they can still make money on their own.
So when you're going to have out-of-state entities registered, specifically recyclers, is that going to be anybody that's collecting material in the state of New York, or just those that are supporting manufacturer programs that are located out of state?
At this point, it would be those who actually collect electronic waste from New York State.
So anyone, regardless of if they're connected to a manufacturer program?
That is the way we are looking to go, potentially, yes.
Would all of the people who are taking material out of state potentially have to pay like registration fees, for example, if they fell into that category, if that's the way you're looking to go?
No, because we're not going to, it's going to be treated a little differently. We're just going to, I mean, we not to get too far involved into the regulations that we're looking at right now, but they wouldn't be, there would not be a registration fee for that group. It would be, you know, if they're coming into New York State and collecting electronic waste, say from a collection event or a series of collection events, or they're picking up weight from business, they would have to register, you know, for that activity and then report to us. We can't regulate a facility outside of New York State, but when they come into the state, we can.
We can regulate the activities they perform within our state.
All right, thanks for that. Any more clarification on that? That's what I get for trying to read a graph just like it looks. Thanks a lot, sir.
Some claim of several million pounds, that's all we really know at this point, where the collections exceed what manufacturers are reporting. Right? Yeah. I'm kind of interested in that.
Can you repeat that? You wanted to clarify to the yes or no on that?
We've asked 3 or 4 times, I think, and haven't gotten an answer, so I think we just kind of move on.
Sometimes, right? How it works. All right. All right. So to kind of round it out and think about all of this in a bigger picture, you know, the benefits of product stewardship, as you all know, are really high as society deals with its solid waste problems and problems of toxicity in a lot of our electronic products and other types of things. It's important to think about how we can reduce the burden on the environment from the get-go. So programs and statutes like this are aimed to keep this kind of waste out of landfills. They are aiming to reduce the amount of stuff that's going in because it contributes to greenhouse gases, pollution, and all these other problems. Plus, there's a lot of valuable materials in these recycled products, precious metals and the engineered plastics. So by recycling, we reduce the demand to extract these things and create these things in the beginning of the manufacturing process, and that in turn reduces the carbon footprint and other environmental externalities of a lot of these products. So at the Environmental Law Institute and other people thinking in this space, as I'm sure many of your organizations and companies are looking at this as a circular economy model where raw materials are re-extracted from the product life out of the products that have already existed and put back into the manufacturing cycle. I would just like to note that there's a lot of good information coming out on circular economy right now. The United Nations has programs on it. EU and China actually just passed a law on circular economy that some of you may or may not be familiar with, depending on if you do work there. But ELI has some resources if this is a concept you'd like to learn more about. We did a full-day conference on it last year that you can find in our archives, and there's also been several articles written about circular economy theory in our publications, the Environmental Forum and the Environmental Law Reporter. So this is just, you know, what DEC is trying to encourage is manufacturers and consumers ultimately and retailers and everyone along the product chain and in the economy to think of things in this kind of system. So some design tips for this type of work to be less environmentally harmful, reducing and eliminating your toxics and heavy metals, minimizing paints and coloring. These are easier to recycle if they don't have that type of thing. Design for a longer life, something that, you know, obviously lasts someone so they don't have to replace it all the time is better environmentally. Using alternate joining methods. This is a specific that I found interesting instead of adhesives, things that I guess snap together and hold together in other ways. And easy repairs and we talked about how you can take back your own products and repair and resell and that type of thing. All of that, there's different kinds of, economic models of ways that it works for companies, but ultimately it's good for the environment if products are being reused and components are being reused and not taking out from primary extraction. There's all kinds of great guidance on this. The ISO 14000 website's here. This is a standard that a lot of you, I'm sure, are familiar with and gives a lot more information about this type of design. Just for an example, Samsung won the Esri Design Award for Recycling last year for easy disassembly, minimal chemical content.
I left.
You didn't need to hear this part. And they replaced conventional plastic with a novel material that was easier to recycle. So this is the type of design that obviously people in this field are striving for, and the Environmental Law Institute and our partners at DC and all kinds of other organizations are working to help manufacturers achieve these goals. And I would encourage anyone, if you're interested in this type of thinking and would like some more information on it as far as theory of circular economy and this type of thinking goes, to contact us, and we're in the process of developing a network as this field kind of emerges. So further guidance is available on DEC's webpage. They have frequently asked questions for manufacturers. We can find updates on all these regs that we've been talking about. And of course, all the online reporting and tutorials that we talked about today are available on DEC's website. Are there any final questions before I thank the folks that need to be thanked and tell you all to eat the rest of our food? One last chance. If you're not about to hit enter on the web, you're out of luck. This program will be available on our website for folks to come back and look to in the next day or two, and it's going to be available publicly. A lot of things need an ELI membership to get through, but this will be in front of the paywall so you can share with clients, with counsel, retailers, partners, that type of thing. I'd like to, again, thank my colleagues, Cynthia and Jay, for being here today, and Colin for coming down all the way to Arlington to help us set up today's program. Thank you to Consumer Technology Association for hosting us, and Dan has been a great help with all of this. Thank you to Peter, Glenn, and Mark, and DEC for all their support throughout this project and throughout our preparation for this program. We really appreciate you guys' time and being with us today. And thank you to all of our participants, those of you who were able to join us in person. It was great to have a full conference room, and everyone online. We really appreciate your participation, and thank you very much.
Yeah, we'd just like to extend our thank you to Environmental Law Institute and Cynthia Harris for all hard work on this presentation, and also to Walter Alcorn and the Consumer Technology Association for hosting this at their meeting. We appreciate that. If you have any questions, our contact information is on our website. Feel free to contact us, because that's really the best thing for us, to get your questions answered so that we can have everybody have a smooth acceptance program.
All right, thank you all, and we'll sign off.
Thank you.